They are directly speaking to millions and millions of people without any level of oversight or regulation. And that has to stop.
Listen to this one. If you're going to pick a fight in Texas, it is reasonable to expect that it be settled there. Fifth Circuit case from 2002. You're damn right. Now, because the court has personal jurisdiction over media matters and those authors, venue is proper in the Northern District of Texas, and Elon has properly pled its claims so that he can actually recover if this moves forward. Media matters and their motion to dismiss is denied. Elon Musk wins a nice victory in the battle for free speech. You can see Reuters is giving us some background on the lawsuit, but it's against Media Matters, a major leftist attack dog organization, constantly clipping conservatives and then making them cancelable for advertisers and things like that. They've been around for a very long time, and they created a very problematic post and report on Elon Musk's X. And so Elon sued them, and there was a big hearing that took place over a motion to dismiss the lawsuit that Elon Musk is bringing. And so we're going to go through this. Now, X has not responded to comment. Media Matters has not responded to comment. But here is what the opinion says from the court, because this is a big deal. It's about free speech in America. And we know that Elon Musk is under attack from many different vectors. He's got lawsuits coming against him. He's got regulatory attack coming against him. He's even got presidential candidates and individuals like Kamala Harris saying that he should be brought to heel. This is a clip that came from 2019, I believe, some time ago. And we know it's old because it's Kamala talking to the press. She doesn't do that now. So this is her talking about Elon, and now he needs to be brought to heel. And so many organizations have launched attacks against Elon, Media Matters just being one of them. But here's what Kamala said about Elon.
He has lost his privileges and it should be taken down. And the bottom line is that you can't say that you have one rule for Facebook and you have a different rule for Twitter. The same rule has to apply, which is that there has to be a responsibility that is placed on these social media sites to understand their power. They are directly speaking to millions and millions of people without any level of oversight or regulation. And that has to stop.
Elon cannot be allowed to exist because he is enabling free speech, and they need fake narratives, just like the Ministry of Truth, in order to secure their victory, because the truth is devastating to them. So here is what a great judge from the great state of Texas had to say about this. You see, the case is X Corp as the plaintiff suing Media Matters for America because of a story that they published. Here's the background on this. On November 20th, X and Elon brought this action against Media Matters and others for interference with contract, business disparagement, interference with prospective economic advantage for what they wrote in their article. Now, pursuant to these claims, X and Elon, they say that Media Matters knowingly and maliciously fabricated side-by-side images of various posts from X that depicted ads next to neo-Nazi or other extremist content. Remember that stupid article where they said, wow, look, this major advertiser Disney is right next to this racist neo-Nazi. They portrayed these designed images as if they were what the average user experiences on X. Now, Elon says that no, Media Matters proceeded with this course of action in an effort to portray X as a neo-Nazi, anti-Semitic platform, and thereby alienating major advertisers and pushing users away from X. So here's the analysis, the good stuff. Now, for specific jurisdiction here to exist, they say Media Matters must have targeted the conduct that is the basis for the lawsuit in Texas. So can Media Matters even be sued? A fair reading of Elon's complaint says that, yep, Media Matters and all of you committed atrocious conduct by engaging in an ideologically driven crusade to damage Elon and X by targeting their advertisers with manipulated information. And the complaint explains that these defendants and others orchestrated a plan to manipulate X to align ads from their customers with inflammatory posts. So they tried to get their posts, like bad posts, next to advertisements. The amended complaint also says that Media Matters posted an article written by the defendant, Hannah Nokai, which described the results of this manipulation. They explained how they did it. The following day, Media Matters published another article written by the same guy detailing its report of this manipulation. The court refers to these two articles as the Hananoki articles. The body of the Hananoki articles targeted, among others, Oracle, which was a Texas advertiser, and Oracle as well. The plaintiff also alleges that this crusade targeted the advertisers. It was AT&T as well, which are both Texas-based companies, and that they planned to do this to take a stand against X, and they wanted specifically specifically advertisers to stop advertising with X. Now, the targeting of this, targeting specifically Texas-based companies. So it sounds like you availed yourselves of that forum. And so as described, each defendant engaged in Texas, and so therefore there's jurisdiction. You came to Texas and poked a Texas company, we'll see you back here. First, there's no question that the author of this, Hanoki, targeted Texas. He included Oracle in the headline and described how Media Matters found that Oracle ads were occurring next to Hitler-loving posts. He also talked about Oracle in his second post. Now, he's provided an affidavit. He says, well, I was not aware that those were in Texas or that those had any Texas residents or Texas users. I didn't know that there were Texas users of X or anything. I didn't know. He also says Texas is neither the subject, it's not mentioned in the article. So these guys are trying to escape. They're like, no, we've never even stepped foot in Texas. So you can't sue us here. That Hanoki disclaims that he was not aware the Hanoki articles had a connection to a Texas and continues to believe they have no connection to Texas is conclusory and it's insufficient. Now, these attestations do not disclaim that Hanoki knew Oracle and AT&T were based in Texas, and he does not deny that he knew of the alleged manipulation and that he and his co-defendant efforts were designed to drive blue chip advertisers away. So we have to take those allegations as true. And if we take it as true that he knew Oracle and AT&T were based in Texas, advertised on X, and he targeted them, then if we take it as true, we have to say there's jurisdiction. Same thing with this guy, Carson, saying he also participated in the same crusade. This guy, Carson, appeared on television, on advertisements, and was a part of this effort. He provided an affidavit saying, I didn't contact any advertisers in Texas. I didn't know about any of the Texas stuff. No one knew that they were based there. But all of this shows he directed his conduct at the advertisers in Texas. He went after Oracle. He went after AT&T. They're based there. That counts. Now, Media Matters too. They also have jurisdiction here. The court must first decide the nature of its website. If the website is passive and specific jurisdiction does not exist, but if the website is interactive, well, we have to take a look. A website is interactive if it interacts with its visitors. Their affidavit says the website is interactive, and traditional jurisdictional rules apply then. For the reasons here, Media Matters targeted Texas. It was part of a strategy to target their advertisers, Oracle and AT&T. They're based in Texas. And so if they wanted to target him, Texas has jurisdiction. Now, in summary, these alleged acts are the basis of Elon's claim. They show that Media Matters and others targeted AT&T and Oracle. Also, they're not being hailed into Texas based on untargeted acts. The alleged conduct was directed at these companies in a way that is different that would randomly affect others. It wasn't like they just went after like X advertisers, and if you happen to be an X advertiser, they targeted these two companies specifically. A defendant who targets a Texas company with tortious activity has fair warning. If you target one of our companies, you can be sued there. Here's the quote. Listen to this one. If you're going to pick a fight in Texas, it is reasonable to expect that it be settled there. Fifth Circuit case from 2002. You're damn right. All right. Now, once a plaintiff has established minimum contacts, the burden shifts. And so here, the defendants are subject to jurisdiction in Texas. And so they say Elon alleges a substantial part of the events occurred within the Northern District of Texas. They say that they waged a campaign against X. AT&T is headquartered in the Northern District. The gravamen of Elon's claims are that they negatively impacted their clients, and that's jurisdiction enough. And so they've got jurisdiction. And they also filed a 12b6 motion, very common motion in these claims. It's failure to state a claim. They say, well, look, even if you have jurisdiction over us, there's no claim here, so it can't survive. And so the judge is going to dismiss this one as well. To allege a case of tortious interference, all you need is to show a prima facie case is these elements: an existing contract that exists, a willful and intentional act that interferes with the contract, and injury that's proximately caused. Those elements. They say, well, Elon has provided enough allegations to survive a dismissal today. Here's what he's alleged. Elon says, well, there was contracts that existed between X and the advertisers. They were subject to interference if somebody tries to interfere with those contracts. There were intentional acts. They wrote an article, created a narrative to interfere, and there was cause. They actually lost advertisers, and they caused that. So it cannot be reasonably disputed that Elon has named parties who contracted for paid ads on X. Media Matters reporting has acknowledged that, even in their own articles. So we got that element checked out. Next, they say there was no breach of contracts, but they're misstating the law. And finally, Elon also plausibly alleges that Media Matters caused their harm. The court will not choose against competing inferences. And so Elon says we can show that we've been damaged. The other side shows, no, those aren't real damages. And he says, so I'm not going to be in the business of deciding that now. They've shown enough here to survive the 12b6 motion to dismiss, so the claim will move forward. Now, also, in other words, they can meet meet those elements, at least at this initial stage. The elements of a business disparagement claim are also as follows. The defendant published false and disparaging information about the business. There was malice. They were acting with some spiteful ill will. They didn't have the privilege to do it, and it resulted in damages. Now, Media Matters says this claim won't survive. They say, well, we never committed actual malice, and there were no special damages. Judge says, I don't know. Well, first, construing the facts that Elon says in a light most favorable to Elon, they say that you guys manipulated and intended to deceive Elon's advertisers. That's sufficient. They say you acted with malice by saying that your reporting was false and it was intended to despair. There's an inference of actual malice there. Now, the judge says many of these facts are disputed, no doubt, but there's enough that's been pled here to move forward. To survive a motion to dismiss on this other claim, all it has to be is a small showing. Elon has done that. Thus, there's been a plausible claim about tortious interference, and so that survives. Now, because the court has personal jurisdiction over Media Matters and those authors, venue is proper in the Northern District of Texas, and Elon has properly pled its claims so that he can actually recover if this moves forward. Media Matters and their motion to dismiss is denied. Get out of here. So that doesn't mean that Elon wins the case, but it does survive their attempt to dismiss. This is a major hurdle in civil litigation, and so it's a big one. It's a good win. This case can move forward, and Elon can start digging into discovery, and we'll start to unpack what Media Matters really did here. And so, big victory to Elon. Good news on that front, and of course, we'll cover more free speech battles here. We'll see if Media Matters owes Elon Musk damages for making up fake stories. Thank you for subscribing, my friends. Thank you so much for joining us here today. Thanks for inviting a friend or family member to come over and join us on the next one. We'll look forward to seeing you and them back here at that time.